When I started putting together the dream team to talk to you guys, a lot of people, there's trepidation around public speaking. And I really had to leverage some relationships to get some of the people to come on stage because they're better in the back. They're better not on stage. And so I am so appreciative for them stepping out of their comfort zone to share the information that they're sharing today. Are you guys finding value? Is this something that as we parachute into other markets around the country that you'll share with your family and friends, that when we come to Boston, when we come to DC, when we go to Atlanta, when we go to Houston, that you're going to tell them that they should come? Yeah. Okay. I'm excited about it. Boy, look, y'all see them attorneys? They already I didn't even get to put the music on. They just stepped on stage. Listen, let me say this. As a real estate investor, as a person that gets calls, emergency calls all the time, this next panel that we're going to talk to and talk about, there's a lot of things that happen that doesn't have to happen if the paperwork and documentation is right. I received a call. I've been a mortgage banker for 25 years. I received a call about 3 weeks ago from my business partner at the end, Melinda Miller, that, hey, one of our clients had a massive heart attack and died. They had been in the house a little over, I think, 19 years. So the widow, she said, I think the widow's going to call you because she doesn't have the financial ability to keep the house. So she called and she said, Tommy, I want to sell it. Well, they were a blended family. And so I didn't have the courage to tell her at the time. I didn't have the heart to tell her because they were planning the funeral. So I called Melinda back and said, she can't sell that house because he had previous kids and there was no will. That part. So after the funeral, we let a little time lapse. And so I had a conversation with her. And I said, hey, there's some what's called unintended heirs that we got to contact. He had 2 daughters. And one of them was estranged. Right? So guess which one didn't want to sign the paperwork? So guess who wanted to hold the entire transaction hostage? So guess who, if they would have came to last year's seminar and got their paperwork in order, we wouldn't be talking to a daughter. Because when I called the widow and said, hey, we can't sell this house, she said, she's been in my house one time. That was me in his house. We've had that house 20 years. Not so much. So the next panel that we're going to talk about, listen, I brought you the best of the best. Google all 3 for what they do. They're extremely proficient and they are legal tacticians in what they do around paperwork, around wills, around trust, and around probates. Because one of the things that keep you from being able to pass the bag to the next generation is paperwork. Where was I? I'm trying to think. Oh, for my students that came to the eviction court with me, do y'all remember, by show of hands, the lady that said, well, no, he told me, because they lived together for like 15 years. If the students are in here, raise your hand. No, he told me that I would get the house when he died. And the judge said, that's not how that works. And she said, and she had very broken English and she was broken. She said, no, he told me, he promised me that I would get the house. And the judge said, unfortunately, that's not how it works. The house reverts back to the original owner. So these people here are going to help you get your affairs in order. They're going to protect what you have, and then they're going to help you pass it. How many people No, don't raise your hand on this. How many people got kids and you love them? But you know, something quite ain't right. That elevator don't really go all the way to the top. Well, they're going to talk to you guys about putting stuff in place that you can protect your kids from themselves. You can put morality clauses. There are so many different things that you can do from the grave to protect. Robert's in the back. We had a deal last year where this dad worked over 50 years to leave an inheritance to his 2 daughters when him and his wife transitioned. And they blew through over $1 million liquid, 2 properties. I wound up buying one that was going into foreclosure, and then another property. So they blew through about $3 million in about 3 years, Robert? That part. Took 54 years to accumulate, took 36 months to blow through. That didn't have to be that way. Now, both of them, I'm very sensitive to this, both of them have diagnosed mental illness problems. So there could have been things that could have been put in place to protect them from themselves. So without further ado, we're talking to the legal minds about wills, trust, probates, and all the stuff that ain't fun, but you need to know about. So I'm going to start off with a question for this panel. If it's just me and my wife, or I'm single, all I got is a house, a 401k, and some money in the bank, I don't need to come pay y'all a bunch of money to do a will.
Is that a question or a statement?
That's a statement.
Well, first of all, let me introduce myself. My name is L.D. Thomas, and I am a local estate planning and probate attorney here in the DFW area. We have clients all over the state of Texas. And I get that question, honestly, a lot, because there is a lot of talk now, especially on social media, about estate planning, the importance of it. Social media will tell you absolutely everybody needs a trust. So I get a lot of questions, and that is one of them. It's just me. I just have my car. I'm just in an apartment, those sorts of things. I will tell you, absolutely every single person over the age of 18 needs an estate plan. You need some sort of will. You need documents in the event of your incapacity, everything. I have had clients from as young as 18 all the way up to 98 years old. When we talk about an estate plan, most people think, oh, it's just what happens to my stuff when I die. And that is not the case. You need to make sure that you have documents in the event of your incapacity. Especially this group, if you have a business, you have investments, you have accounts, if you are taken out of commission for any given length of time, we're going to pray that you get back up on your feet. And when you get back up on your feet, I bet you want your businesses and you want all of your accounts to be running just as good. So medical power of attorneys, financial power of attorneys, all those things are important, regardless to the size of your estate, whether it is a modest estate or a large estate. Everyone needs a plan. So telling me it's just you and your dog, well, if something happens to you, who's going to take care of your dog, right? So everyone needs an estate plan.
Okay, all right. So, Attorney Cheatham, what type of client needs to come see you?
Okay. I am Attorney Cheatham, Attorney Wynthia Cheatham, and I too do estate planning, probate. I do guardianships. I try a lot of these cases. I deal with all types of disputes. Now, the type of client that needs to come to me is everyone. And I want to first address you young people, the people in the age of 20. If you're here, listen to me. You're the ones who first think, I have absolutely nothing. I just got out of college, or I just got out of high school. And for those parents who have those 20-something-year-olds who don't have an estate plan or who are not even focusing on an estate plan, guess who's the richest among you? They are. Why? Because they have digital assets. What are digital assets? Digital assets are those items that you can't quite touch. It's not money. It's not the painting that you can see on the wall. It's the cryptocurrency. It's the NFTs. Okay? Those are things that you can't touch, and our young people are the ones who own them. And they are worth millions and thousands of dollars, period. Any given day, they can escalate to a complete wealth management plan. So they are the ones, and you are the ones, who need to focus on an estate plan. I'm going to pull out my little paper because I need you to, I don't want to mispronounce anything about digital assets. All right. Digital assets are controlled by what's called the Revised Uniform Fiduciary Access to Digital Assets Act. That's a federal legislation. And those digital assets are controlled by that particular statute. But the first place that those digital assets are controlled by is the agreement. How many of you have gone onto the internet and you're getting ready to purchase something and it says in a little box, I agree to the terms of this agreement? Guess what? It is that agreement that controls that digital asset. For instance, how many of you have Facebook? How many of you have frequent flyer miles? How many of you have, your credit card gives you additional, what they call points and benefits? So you too have digital assets. That's what that is. All right? How many of you have invested in what are called NFTs? And I'll give you the exact name of those things because I can't remember all these acronyms. Non-fungible tokens. That's what they call them. Non-fungible tokens. How many of you have cryptocurrency? There you go. Digital assets. The reason I want to focus on that is because it's very important that you include that in your estate plan, because when you do pass or when you become incapacitated, guess who cannot get to those? Your loved ones, your fiduciary, the person that you appointed to manage those. They cannot get to that. They cannot recover it for your estate unless A, you have put something in your estate plan, your will or your trust or your guardianship plan to allow them to get into those particular digital assets. Who would want to lose their cryptocurrency? I don't think anybody would want to do that. And for people in their 20s, if you're investing in that cryptocurrency or those NFTs, you need to protect them and you need to be able to pass them on because that is part of your legacy. You want to preserve it. You've got to get with an attorney, and what my biggest tell right now is, don't let your attorney do your estate plan without including your digital assets. Pass it on.
Wow. Okay. So I can wheel my frequent flyer miles to somebody?
Yes.
All right. See, I didn't even know that. See, look at her. Okay, that was good. Somebody can go to Hawaii for free. Okay. So, Attorney Brooks, I have a house. I want to reduce my digital footprint in the world. I hate the fact that anybody can put my name in and go county to county and find all of my assets. I want to move one of my real estate holdings into a trust. But I was talking to my buddy, my buddy Bob, and Bob knows everything. And Bob told me that if I do that, because my mortgage is with Wells Fargo, that Wells Fargo can enact the due on sale clause and call the note due, even though I've never been late. But I really want to get this house out of my name, and I want another layer of protection. How can they do that? How can I usurp that, stay in good standing with the mortgage company, but also protect my family?
So that's a great question, Tommy, and good afternoon, everyone. My name is J.C. Brooks. I am a generational wealth planning and real estate lawyer with offices here in DFW in Houston. And so, Tommy, that's actually a question that I have a lot of clients that we deal with. And typically, that question is going to revolve around, number one, trust, okay? In particular, a living trust, a revocable living trust. And when we talk about what a revocable living trust is, first, there's two types of trust. There's a revocable trust and an irrevocable trust. And from that, you can go down a rabbit hole of a number of different things from that. But those are the two basic types of trust. And so when you are dealing with that scenario that Tommy laid out, there's a number of things that we have to determine. Number one is this a homestead property or not? Because there are different rules from the federal government in regards to dealing with a homestead property as opposed to an investment property. So let's say, Tommy, in your scenario that this was a homestead property, and let's say we put this into a living trust. Again, as you mentioned, if this had a mortgage on it, there is in almost every mortgage, there is what's called a due on sale clause, meaning that if you convey that property, and conveyance can be something as simple as doing a deed from yourself to your trust or doing a deed from you to another family member, the bank is going to consider that a conveyance, a sale. When that happens, they can accelerate that mortgage and say that it is due immediately. When you have but when you do that with a living trust, if you structure it properly, okay, you can, and it's dealing with a homestead property, you have protection in the federal law, and so most banks, such as I'm sure Wells Fargo, they understand that. Now, let's say we're talking about an investment property. That's a little bit different, and in those cases, when you're dealing with an investment property, you can still put it into a trust, okay? But you have to structure it a little bit differently, in particular if you're in a rising interest rate environment in which, let's say you purchased that home and it was at 2%, okay? And now the interest rate is at 7%. Well, the bank may decide, if they know that you have conveyed that property, to accelerate that due on sale clause, because they may calculate that they can make more money in those mortgage payments. So we would structure that into what's called a land trust, okay? And a land trust is very similar to a living trust, but it's specifically structured for a piece of property. The other thing that a land trust does is, again, if it's structured properly, it will give you some anonymity, okay? Which is, for a lot of real estate investors, the thing that, if I can give you three things today to remember, is number one, you want to avoid probate. Number two, you want to minimize your risk, and you want to minimize liability. And so you want to make it very difficult for anyone to know what assets you own, okay, where they are. Basically, you want to control everything and own nothing, okay? and I have that strategy because if my ex-wife comes in and looks at me personally, I have nothing. I own nothing. So is this on tape? I own nothing.
Okay, all right. So let me tell you why that's so important, right? So in March of this year, I was in a wreck. A young man ran a light and hit me. And when he hit me, I immediately asked for the insurance. And I saw that on the insurance card, attorneys, that the address was different than his driver's license. That takes me back to my old loan officer days. So I looked at it and I said, the addresses don't match. And he says, well, my insurance is under my parents. So we're sitting there waiting on the cops to come. I just go to Dallas County Appraisal District, put in the address, and it gives me the name, his dad's name. Then I go cross-reference. We're doing all this while I'm doing this in a matter of minutes. I cross-reference and I Google the dad. He's a surgeon. Then I go back to Collin County, Dallas County, and Tarrant County appraisal districts, and I put his name in the search. Dad owns 11 houses in his name. His son was on his insurance policy. I called JC. So in 3 minutes, I found 11 properties, rentals, all in his name. He's at work, I'm assuming. His 21-year-old son is texting and runs a light. It ain't his son, because his son worked at like Quick Trip All Service something. I'm looking at the 11 assets. But just that quick, I pierced whatever. Guys, you want to lighten your digital footprint. You want to lighten. How could he have structured that? Attorney Bruce, what could that doctor have done that I couldn't have found any of that?
I would say first and foremost, for any, in particular, real estate investor, anyone who has a real estate business, first and foremost, you need to make sure that your business is structured properly. You need to make sure, let me say this, if anyone in here has a rental property in your name today, you need to get it out of your personal name. You have unlimited risk. You have unlimited risk. And lawyers, we will find stuff out. Believe me. So what you want is you want to make yourself invisible as much as possible. And there is a number of different structures that you can utilize. We can create what's called an anonymity structure. If you really want to be invisible, you can have a structure in which you use a LLC from a state like Wyoming or Nevada, and you create that LLC, and that LLC then owns a Texas LLC where the assets are actually held.
So let me say this real quick, why that's important. The reason it's important that your LLC is in a non-disclosure state is because they don't disclose.
Right.
Right? So if you have an LLC in Texas, and if I know the name of the LLC, I just simply jump on the Texas Comptroller's website, put in the name of the LLC, and all of your information comes up. So where's the anonymity in that? I just found you. But if you go look me up in Wyoming, if you look up my LLC, you can't find anything. I'm sorry, go ahead.
No, that's absolutely right. And typically, when we create that, I'm creating it for my client. So if they see anything, they're going to see my name. They're not going to see my client's name with that. And then we can also do things on the back end, because clients will say, well, you know, what happens when it's in your name? No, there's things we can do to make sure that the actual owners and things have the actual ownership in these structures. But you have to have these structures in place if you want to have anonymity and you want to make it very, very difficult for lawyers, creditors to find out your assets, what you own, how much you own. That is an absolute must.
So let me ask a question to the three attorneys. Somebody comes to you, they want to sue me. No, I ain't putting that out there. They want to sue somebody. No, we ain't doing that one. They want to sue somebody. And so as an attorney, before you take the case, you do research. And you find no assets or very little assets. Do you either do a large retainer or you say I'm not interested, on average?
Normally, if what you have to do, you can't just stop at that initial conference or the initial consultation. And you have to do, as an attorney, we will do our diligence, due diligence to find out what your assets are, if any. And we don't stop with just a conversation with you. There are many, how can I say, websites that we can go to discover what your assets are. We also, and the biggest disclosure item is the county clerk's office. That's the biggest disclosure item, because most of what you have to file it with the county clerk's office. Your powers of attorney have to be filed there. Your deeds have to be filed there. Sometimes people will even file their trusts there. Your will has to be filed with the county clerk's office if you want it to keep it in safekeeping. You deposit your wills at safekeeping in the county clerk's office. The thing is, you don't, as far as a cost is concerned, and whether or not you will be able to just quote a price without knowing all of those whether those assets exist or not, we don't typically do that. We do our due diligence and research you before we give you a quote, because our fees are based upon the work that we have to do. So depending upon the number of assets that you have, the things that we need to identify so that we can protect that stuff, that's what drives the cost. There's no quote unquote $1,000 attorney fee. That is a myth. And if you come to if you come to an attorney's office and you're expecting that to pay $1,000, you're going to get disappointed. Especially if you've got 6 oil and gas interests up in West Texas, or you've got a property interest that you just inherit that's got 87 heirs. You're going to get disappointed. That's not going to be the kind of price that somebody can quote you. And it's all driven based upon the amount of energy and time and expense that we have to endure and put into your case. So there's no fee.
Okay.
We would know.
I'm going to take some questions from the audience. So I want the runners to get the questions ready. But I named this panel, if there's a will, it may not be the best way.
Yeah.
So I want you guys to talk about, most people don't have a will, but if they do have a will, they think everything's taken care of, that they're fine.
That's not the case. Let me tell you about a will. The reason I want to discuss a will with you, because you have options. You can have a will, and you will have to pay the attorney to get that will probated. You may spend, somebody may say, all right, yeah, I'll charge you $1,000 to do that will. However, your family members are the ones who are going to suffer, because they then have to go to the probate court with an attorney. You can't do it by yourself. They will go to and spend the money with an attorney trying to get your will probated. Now, it depends upon what you have going on in your estate. If you got those NFTs or those digital assets, they're going to work, because that's not going to be in your will. Guess what? If you have a will now, what you need to do is revise it. Go back and look at it. Take it back to your lawyer. Have them take a look. Hey, how about these digital assets? I don't see any of that in my will. You truly need to go back and do that. If you don't have a will, that's where it really gets expensive for your loved ones. One of the best ways to avoid probate is to engage in a trust. Spend that money now, and your family doesn't even have to go see a court. They don't have to hire a lawyer at that point if they are able to read, write, and spell and understand what their responsibilities are as trustee. Trust is your best option. It is more expensive today, but it is much more expensive if you don't do a trust and you leave that burden to your family after you die.
So, Attorney LD, I was told that if you have a will and you die, everything stops because there has to be probate. But if you have a trust, nothing stops. So why wouldn't everybody just do a trust?
That's an excellent point, excellent question. I don't really like to deal in absolutes of everything stops, but for the most part. So let's just talk about bank accounts and talk about real estate and the transfer of those assets. If your primary estate planning document was a will, there is a period of time once those institutions are notified that the decedent has died, those bank accounts are going to be locked down. There's going to be that in-between period. The thing about that is because a will transfers your assets once you pass away. One of the things that's important to understand about a trust, and this is key, having a trust is wonderful, but that is just the first step. You must fund the trust. Raise your hand if you know exactly what that means when I say fund the trust. Great. That means you literally have to transfer your assets out of your name, just like Attorney Brooks said, talked about those houses. They have to come out of your name and go into the name of the trust. So when you pass away and you've used your trust as your primary estate planning document, it's essentially a management playbook. Someone, if it was done by any of the three of us, not only do you have trustees, but you have successor trustees, and you have all of these things in place to keep the train on the track. And since your assets were transferred into the trust before you passed away, that's why that eliminates or minimizes the need or likelihood of your family having to go through probate. So that's why a trust kind of helps things continue to move along. But it's key and it's important because you will have, listen, you guys, he was not lying, and I'm not just talking about me. Y'all have some of the best up here. But there are some of our colleagues out there who will sell you pieces of paper and send you out the door, and then your loved ones end up in probate anyway. So you spent more money on the front end. They didn't talk to you about funding. They didn't talk to you about transferring those assets. And all you have is a big leather binder that you think is doing something, and it is not going to do any of the things that you think are necessary. So, that's how it works.
And so, again, I could give you countless case studies when I have sat at families' kitchen tables and they thought things were airtight and they brought out paperwork. And from what I've just learned over the years, being a real estate investor, I'm not licensed, I'm not an attorney, right? But I can see holes
Absolutely.
in the stuff.
Yeah, and I think they'll back me up on this. That people come to us after their loved ones have passed away thinking that things were done because the communication to the family was, oh, well, mama did a trust, or mama called somebody on the TV, or nowadays, uncle, clicked a button online and did his own thing. And
or went to LegalZoom.
You said it, I didn't.
I ain't licensed, I can say it.
But this is why it's important, and I kind of want to piggyback on what you said and what you said as well, whether or not it's a will or whether or not it's a trust. When you come to us, one of the things that we have to do, everyone is different. Everyone's goals are different. For some people, a trust is the absolute best way to go. However, if you are 18, 19 years old and you're just starting out, okay, maybe a trust isn't the best way. But we need to sit down and we need to have that conversation. Everybody's estate plan should be tailored to their goals, their needs, their assets, their family. Everybody in here is different. And so just going to LegalZoom, okay, I don't like to put people down.
You want me to say it again?
Yes.
LegalZoom.
And just clicking a couple of buttons and spitting out paper, that is extremely dangerous because there are so many steps. It's not just having the paper, it's what you do with the paper. Were the documents properly signed? Were they properly executed? Did you have a consultation with someone to help you and guide you along that process to make all those decisions, or did you just pick somebody's name out of the air? Those sorts of things. It's important, and I'm going to tell you this, that you sit down with someone like us and have that conversation.
Okay. All right, I want to take questions now. I thought there was a question. I need two runners because this is going to be good. Okay, first question right here, Zay, and then right here in the yellow, and then I need somebody to get Juanita in the back, and then somebody on this side. Okay, go ahead.
It's very quick. I have my oldest son is 14 and has autism. He has disability. How should I protect him? What are some things, just examples, and maybe we can sit down later. What do I need to do to protect him, myself, and his siblings in the future?
Absolutely. That is one of the most profound questions that we have. And I got to put my stuff down for this one. All right. There will be a period between having complete cognitive understanding of everything going on and death. Death is over here. Between here and here, there is a need for what is called a guardianship for anybody who has an incapacity or has gotten an injury that causes incapacity. We are not likely to just be sitting around watching television, enjoying our families, and then in a minute we die. That is not how this works. There will likely be an illness. And the way you cover an illness is, one, you can have what's called a power of attorney, if that person is cognizant enough to execute a power of attorney. That gives you financial control over that person's estate while they have an incapacity. That's the least expensive opportunity to manage someone's estate if they have some form of an incapacity. If that period comes up and you don't have a power of attorney, then you go into what's very expensive. It's called a guardianship. A guardianship is this period in between I know what I'm doing and I don't, or death. That is very important to get that part covered. So many people don't focus on that. In addition to that, when you're doing your estate plans, what you also want to do while you're in a good sound mind, you want to pick out that assisted living facility because your family may not be able to keep you at home. You want to go out and explore those things now so that if you get to that point of incapacity, you will be able and know where you're going to go. It will be to your liking, not someone else's. It will not be a Medicaid nursing home. And it will be someplace where you can afford based upon your assets. So that's something very important that you need to concentrate on. And with regards to your son, at age 18, you will be getting a guardianship. And if you don't think about it now, you will be forced to think about it, and you will be forced to pay the costs and expenses for doing a guardianship of someone that has an incapacity or at age 18 will end up with an incapacity. And yes, you do need to speak to an estate attorney regarding that so that you can get him set up and the transition is just as smooth as silk. Because it can be, and it doesn't have to go for years and months, and then you still don't have that guardianship. And also, if your loved one who has an incapacity should ever regain their abilities to take care of themselves, or they, with their family support, they can take care of themselves, you can restore their capacity.
That's good. That's good.
If I could just say one thing about that.
Okay.
The other thing that I encourage people to consider is something called a SNT, known as some people as a special needs trust. I use the term supplemental needs trust because I think it underscores what that does. And so if your son or any of your loved ones are receiving governmental assistance that is income-based and you pass away and you leave them something, you put their governmental assistance in jeopardy if you don't have that supplemental needs trust. So it's a special trust that you put together that says, hey, leave that money alone. We will leave this to them and it will supplement that. So it's certain language, it needs to be crafted a certain way. So for anyone who has a loved one in their life that currently or may in future, well currently has assistance from the government that's income-based, you definitely want to have that conversation.
Wow.
And just to piggyback off that, absolutely with special needs trust. And as he talked about earlier, when you have that, one of the keys is making sure that it's properly funded, because what you don't want is to set that up and then not have it properly funded, and then your son is not able then to use those assets. And I know one way, we had some people in here about insurance, that's a way that you can fund that trust.
That's good. Ronice?
Good afternoon. Okay, so if I just started an LLC and I have $20,000, who do I give my money to? The tax attorney, the financial planner, the mentor, the insurance?
Eventually, everyone. So when you're starting a business, you're going to need to, again, I go back to this. When you have a house, the most important thing when you're building a house is the foundation. And if you don't have the proper foundation, I don't care what you build on top of that, at some point, it's going to come crashing down. And for business owners, that foundation is having the proper legal structure. And whether that's an LLC, I know a lot of times we talk about LLCs, but it may be a C corp for someone. It may be, since we're talking about real estate, you may need some type a limited partnership, in particular if you're dealing with commercial properties. So the key thing is having that proper legal structure to put you in the best position going forward. And then, of course, you always are going to want to have a team of trusted advisors, and that's a lawyer, that's an insurance agent, that's a banker, that's going to be for since we're talking about real estate, a real estate agent, people of that nature. I forgot one of them, a CPA. You most certainly are going to want to have a CPA, because when you get into these real estate streets, if you can't be doing the work and doing all this thing on the back end, you need to have professionals that are taking care of that for you.
All right. Here's our last question right here.
Can you give us some takeaways as it relates to being a real estate investor and prenuptial agreements?
Oh, yeah.
Ooh, get one.
Absolutely, get one.
Listen, so here's a funny story, okay? Before I even graduated law school, because I graduated law school in the age of social media. Before I even graduated law school, I had people in my inbox asking for advice on family law issues. It is full of drama, okay? And I said, I'm not doing that, okay? I don't have time to deal with all that drama. And then I ended up in probate, okay? All right, let's all laugh together. But absolutely, it is not an indication of how much you love this person. It is just the prudent, most responsible thing to do. And I encourage you to get with a family law attorney to do that. And I have some that I work with, and because there's some overlap there, because not only do you need that prenuptial agreement, but you want to make sure that it's signed again and executed appropriately. Make sure that the other side has been advised separately, so that if they ever do question it, you know, well, listen, that was your lawyer told you that. So they can't say, well, you know, I went to her and she had this lawyer and they just told me to sign something the day of the wedding. So I highly recommend that. Whether you are investing in real estate or just going to the beach every Saturday, I don't care what I tell people, I don't care if you got 2 nickels, them your 2 nickels, okay? and it's so funny because I just had this conversation with someone. A prenuptial agreement is simply a plan just in case. Yeah. If you get on an airplane, you got to sit there and you have to watch those flight attendants tell you this is what's going to happen just in case of a water landing and you're going from Dallas to Austin, okay? Why are you telling me about this water landing? There's no water there, but it's just in case. And that's the same with the prenuptial agreement. It's not saying that we're going to get divorced, but and let me talk to you about this while I still like you. Right? Let's make this easy while I'm in love with you. This is what I would like to do. So that's my 2 cents on that.
That's good. Next question.
Hi, my name's Krista, and thank y'all for all of y'all's advice. Just a quick question. You mentioned to have an LLC in a non-disclosure state and then have that own a Texas LLC. But if you already created your Texas LLC, is there a way to go back and create an LLC in non-disclosure and then it own that? Does that make sense?
So the answer is there's always a way. We may have to do some things in particular so as far as creating the LLC in the non-disclosure state, that's not a problem. What you then have to look at is we may then have to transfer the ownership interest into the a new LLC in Texas. To give it true anonymity, because again, and a lot of people, as Tommy said, they don't realize this, is when you go to the Secretary of State, in particular, if you are a member managed LLC, when you're a member managed LLC, you're basically telling the whole world in the state of Texas that I own this business or this LLC. So at the very least, have it to be manager managed. You know, again, you want to put as many layers on top to give you that protection, and then you know you may have other hierarchies for your different businesses as well. Again, an LLC is one option. You know, we may look at creating some type of a different option as well.
Okay, last question, Juanetta, your question?
Hi, thank you for taking the question. If you die with a will and you have assets, but you do not probate those within the lawful time frame, because I believe in Texas there's a time frame, that's essentially, well, how do you begin to kind of put that back together again for the heirs that remain?
Attorney
and can
Bushler.
any heir initiate probate?
All right. The statutory time period for probating a will is 4 years from the date of death. Here's the whole thing about wills. How many of you have ever had somebody come to you and say, hey, Big Mama left me the house, and it's right here in this will? How many have had that happen to them? Or you know somebody? I know. That will is not valid until it is probated. So if Big Mama put that in the will and you didn't probate the will, then you've got zero. You are not appointed as the administrator. You have no authority, and nothing can transfer from Big Mama's estate to you or anybody else. That's the first thing. Especially if you don't do that within the 4-year time period. Now, we are required to identify that there is a will, and we are required to give that will and present it for probate if you have ownership of it or ownership of a copy of it, because a copy of a will can be probated. The important thing is, if you fail and you have that will in your possession and you fail, you can be found by the court to be in what is called default. That's a penalty. That's like being in contempt of court. Okay? So don't play with that. Give the will to the court. Give it to whoever you think should be the administrator. Try to get it done within 4 years. Don't come like I have clients where they come 9 years later and they say, oh yeah, now I have the will. I had it all along. And I'm going, oh my God. Don't tell me that. Because the court could penalize you for not doing that, not bringing that will forward. Now, whether you can probate it after the 4 years and who could possibly probate an estate after 4 years, you have instances where if you have a will, it was actually lost, nobody was hiding it, nobody's in default, you can bring that back to the court and you can possibly probate it as what's called a muniment of title, or you can probate it as a full will if there's lots of assets and things need to get taken care of. But you do have options, but you've got to present to the court first, A, there was no default, nobody was hiding it, it's the original will, it hasn't been revoked or anything, or, withdrawn. So those are the things you can do, and yes, any individual who has a copy of that will or has knowledge of that will can go to the court and ask the court, hey, I know Johnny's got that will, can you make him produce it? He's in default. Or if you have a copy of the will, you can probate that will, even if there's an administrator or an executor identified in that will. The court will simply have that person served and say, come to court and show why you should be appointed as the executor.
Wow.
That's what the court will do.
That's good. How many people would agree that there's a lot of complexities to make sure that your legal affairs are in place? How many people will agree that you need to contact these individuals or someone like them if you don't live in our state?
Oh, okay. Don't you stay in Texas? You need to call one of the three others.
That's right.
Okay, so this is what I want to do. As we wrap up, Attorney LD, give your contact information, then Attorney Brooks, and then Attorney Brewster, give your contact information.
Okay, so what I'm going to do, I don't follow instructions very well. I'm going to leave my cards at the front desk. It has all my contact information on there, but I'll take this moment because I did want to say something, and it's on me to say this before I leave. Estate planning is not only about what you have today. It's not about just what you know you have. It's about things that you don't even know are coming your way. I almost fell and broke my neck trying to come up here, right? So, and I'm going to be looking for a person.
Hold on.
Almost.
You got your trust.
But the reality
wait a
is,
minute.
it was not, you are, I'll release you of liability.
My LLC has event insurance. And I am registered in Wyoming.
But no harm came to me. But what I want to say is sometimes, and I've been contacted by personal injury attorneys because someone has passed away in a car accident or a family needs to file a wrongful death lawsuit. And now this person who passed away not thinking that they had very much, their estate is about to be awarded millions of dollars in a lawsuit. And having an estate plan would be important and crucial in divvying up those millions of dollars. But specific to the people in this room, over the next 20 years, $84 trillion is expected to pass from generations.
Wow.
You cannot, I said this before, you hear me say, I say it all the time, you cannot create generational wealth without a plan to transfer wealth to the next generation.
That's the mic drop. That's the mic drop right there. Okay, you're going to leave your cards. Attorney Brooks, how do they contact you?
So I actually have a table right outside, so y'all can come stop by the table, grab my cards. We can chat a little bit if you have time.
Okay.
And please come by.
Okay. Attorney Cheatham, how do they reach you?
My cards are with the blue pen, and the card is inside the ink pen on the table next door to the Wells Fargo table.
Now y'all
So
see
you can
how
go
all
pick
three of the
those up.
attorneys didn't do nothing I asked them to do.
If you want to email me, you can email me directly at ld@ldthomaslaw.com. ld@ldthomaslaw.com.
I'm going to try one more time,
Okay.
Attorney
All right,
Brooks.
So you can call at 877-244-3529 to set up a consultation with me, or you can email me at info@jcblawfirm.com.
Okay, Attorney Cheatham.
All right. My telephone number is 214-293-6771. And my email address is WYNTHIAJ, C as in cat, @gmail.com. And I welcome all of your requests. I'll be happy to give a consultation and assist you in any way that possibly I can.
Give these amazing attorneys a hand. We're not doing the law and order, did we? All right, guys. Listen, man, we're going to keep it going. That was hilarious.